Mr. Chairman, I'm going to start my remarks this morning by putting a request on the record that we have a discussion about moving forward with remote meetings. You have communicated that you have an exemption for a mask, and that's fine. The accommodation under the law for people who have such a situation or condition is to go to remote meetings. And I note that we've had a gentleman join us in the audience who's choosing not to wear a mask as well. And so since we've been provided the tools to move to remote meetings, as soon as we finish with these reports, I think we should recess and move to a remote meeting so that we can all stay legal and avoid potential criminal complaints. Very quickly, I attended many of the same meetings as all of you. Local decision makers meeting last week with the Health District, the Council of Governments Executive Board meeting. Got a call from Department of Commerce talking about economic development issues. We had our special meetings on Thursday as a board. WASAC had a virtual assembly meeting yesterday that Keith and I were both on. That's it for updates.
I'll address the remote meeting. I have proposed to Keith that if you're not comfortable being in here, then yes, and I propose as the chairman, I should be in the council room along with the administrator. If the other commissioners want to be remote, that's your free choice, and it's a lawful meeting for you to be at your desk remotely for the meeting.
Mr. Chairman, before we do that, if I may, we've got
Commissioner Peck has asked for the floor.
We've got some folks that have joined us that, whether you believe masks are necessary or not, it is the law, and I'm going to ask you to please get a mask at the door, as this gentleman in the corner has done. Thank you, sir. It's not our room, it's the public's room, and the law is pretty clear. And so I'm going to ask you politely, please put on a mask. If not, it's an unlawful meeting. We can repeat what we did last week.
There we have a difference of opinion. There's been a lot of constitutional attorneys that have watched that and commented on it. And there is a distinct reasoning with the people to be able to peacefully protest what a mandate and a governor has put down. And if you want to, we can go through that whole constitutional attorney's critique of our meeting. And I would encourage that so that maybe we all can get refreshed on the separation of powers, and that within our own county system here, we have the judicial, we have the executive, and the legislative sitting here as commissioner of the board. And not one of them has more power than the other. There is a big distinction between a mandate that our legislature supposedly granted to a governor, and they can't freely give that power to that governor. It's not written in the Constitution. And all of our rights are supposed to be protected by the three branches of government. Our rights, we the people. This is our government.
So thank you for those observations. I would point out that the judicial branch is not represented by this board.
I didn't say he was. I said we're the legislative and the executive. He is the judicial. He's in the room.
Actually, he's not the judicial either. It's the courts. But listen to the recording later. You misspoke. No problem.
Commissioner Peck, you're out of order. You're out of order. I see Mr. Sanders at the mic.
Mr. Chairman, may I just make a brief address? I think we could all agree there's going to be differing legal opinions throughout the country. In fact, some of the most critical court decisions that have come before this nation have been on a divided U.S. Supreme Court. Those individuals that are on that court are much smarter than I, and they have much more insights, and I will defer greatly to them as far as a balance of their acumen in the law and their recognition of what the ultimate decision-making authority of the U.S. Constitution is. But for purposes of county prosecutors, the county elected prosecuting attorney is the legal advice and advisor for this board. I've been elected by the people to provide this board legal advice. I wasn't elected to advocate my own personal opinions, my own personal arguments that I may have as to individual liberty. My dedication and oath of office is to what that oath of office is the elected prosecuting attorney to provide legal guidance to this board. I have done that. I have done that. And so I recognize what Mr. Chairman has offered is that there's differing constitutional folks out there that may, of course, disagree with me. People will disagree with you. What I look at as your legal counsel and evaluating the 30 challenges to lawsuits in a lawful manner, they took those challenges to court, and they have all ruled that the governor is acting under his constitutional authority. The very definition of an edict, which is often referred to in this body, is a proclamation with the force of law. That is equivalent, whether we have ordinances. I mean,
Can I ask you a question, Sean? With that in mind right there, can I ask you a question?
Certainly.
If a law, you're calling it a law.
Yes.
Now you just referred to it as a mandate. If that conflicts with the Constitution, how can you enforce that mandate and the Constitution at the same time?
So let's go backwards. There's a lot of things that are not in the Constitution. Speed limits aren't in the Constitution. I think it was just a couple months ago, the sheriff presented a need because citizens in our community said, we have racing. We have a need because it's detrimental to the health and safety of certain people in this community.
We're getting off topic, Sean.
No, it comes perfectly on topic because proclamations, resolutions aren't cited in the Constitutional either. What we look at is we look at our state constitution, and the legislature has the authority to determine what duties each of the office holders at the state, governor, lieutenant governor, all those positions, prosecuting attorney, the legislature gets to say what those duties are. And so if we can have respect
please be quiet in the audience. Please be quiet in the audience.
You have an opportunity to speak. Everybody has an opportunity.
So what you're telling me then in that statement right there, the legislative part of our government has all powers in them.
No.
Well, you said they gave him the power. How do they give him the power?
From our state constitution. Separation.
Our state constitution says that all powers are derived from the people.
And the people are the ones that participated in a very valid and constitutional process of elections. And that's how we elect office holders. And those office holders, like we had last week, they came here and shared that they participated in
There was one.
I'm sorry?
Brad Clippard, that's one.
Brad Clippard basically represented a near majority of the vote that took place in 2019 when that law was addressed and modified. That law had been in existence for several years.
You keep saying a mere majority. Was it a majority? Was it unanimous?
There was one Democrat senator and one Republican senator that dissented.
There you go.
But it's clearly a majority. If we're saying that it wasn't unanimous, therefore it's not of the people, I think we need to all go back to figure out what the constitutional.
So you're saying then Rosa Parks was the tyrant back when the civil rights, because she wouldn't comply. She's a tyrant. You said that last week in the meeting.
No, I didn't.
Yeah, you did.
No, I did. Not at all. I guess what you're now complaining is one's being discriminated against based on their race, color of skin is the equivalent to a mask mandate. Is that what I'm hearing?
Is that a question? Because a mask mandate affects everyone's health.
Okay.
Not just a race.
So here's what we're talking about, and I think what the board has put forward is the question is, does the governor have this authority to issue proclamations, to issue mandates? The legislature says, well, why pass a law if it doesn't carry the enforcement action of the executive, which they granted as well. They said it's a gross misdemeanor if you violate those proclamations. So that carries with it the force of law. So it's very clear that our balance of powers, the legislature contemplated this. In fact, they had the opportunity to keep that 30-day limit on it, but they chose not to. They chose to move that 30-day limit only into Section 2 of the statute that addresses the state of emergency powers. It's still consistent with the Constitution. These have been challenged in our court, which is the proper method of people to challenge when they believe that their government has acted inconsistent with the Constitution, inconsistent with the laws. They are encouraged to challenge it. We have people in our community that have challenged it. 30 different lawsuits have gone forward, and they have all validated that the governor, whether you agree with it or not, he was acting under authority of law, and it's been held to be constitutional. I think I made a perfect record last week. I would just ask the chair to follow that guidance. I recognize there's other challenges pending in court.
Personal choice.
Well, it's not a personal choice.
Yes, it is.
Is it a personal choice then for someone to drive the speed limit, or can they say, I believe I could drive 80
That's their personal choice. They'll get a ticket if they don't.
Well, very well. So
there you go.
So the argument that there's a consequence to failing to follow the law.
There is.
I've laid that out.
And I guess we're pushing that issue, just like Rosa Parks. So if we could, we'll continue with the meeting unless we're going to have commissioners walk out again. So with that, we're going to move on down to the closed record hearing.
I would simply ask the board, again, we're at the same position where we're now going to have a closed record hearing and there's going to be subject to challenge. I would ask if the board is going to allow people to exercise their right to come here and not follow the proclamation and what the law requires of us to hold a public meeting that is open to the public, to follow that law and protect the health and safety of others, whether you agree with the mask mandate or not. I would suggest that we move to a virtual meeting like we did last year.
That's fine. I'll stay in this room and the other commissioners can go to their offices, and I'll stay in here and I got my social distancing. I ain't close to anybody, and we'll conduct the meeting.
And you could follow the order that was previously issued because you wore a mask last year during 2020 when we had meetings and that we were allowed small.
If you go back and look, that mask wasn't up over my face much of the time.
Well, okay, well.
I can't wear one, John. If I put that on my face and I have a cardiac arrest, are you going to be liable for a lawsuit?
So here's
after I warn you about the HIPAA?
So here's the thing that we have. Every public employee, every employee in this courthouse has to comply with the same law. What the process requires is that they would then provide HR with a copy of their medical exemption, and a reasonable accommodation can be made. Well, guess what? The reasonable accommodation is that we could participate and conduct the business of this county through virtual means. You have just as much authority to participate in your office through virtual means, just like you do here in this meeting present. Because when you choose to say it's your medical issue that overrides somebody else's medical issue, what if someone else is also an employee of this county that has compromised immune system or other medical needs and they don't want to catch whatever other people might be sharing?
Then they should take that responsibility on themselves and stay home and conduct their business from home.
So now,
Sean, it's personal responsibility. Now listen, you're telling me that the alternative that we're at right now is that the government can pick and choose which laws they want to enforce, and we the people have to abide by the government. No, this is our government. We the people.
You're exactly right. We are a government of the people, and the people elected people to go to Olympia, in this case, to pass laws that everybody should have to follow. If we get to simply decide which laws apply to us and we get to pick and choose, we as the government, and as your legal counselor, I'm saying we as the government should be the example and follow the laws that were passed by the people.
I disagree.
Well, I know you disagree. And
right.
30 other court cases have agreed that have granted the governor this authority. So I've made my record. That's fine. You can proceed.
Okay.
How you want.
Closed record hearing. Cup
Mr. Chairman, point of order.
Commissioner Peck, point of order.
I want to be on the record that you're calling to move to this next agenda item, which is a quasi-judicial land use matter. Clearly, in my opinion, and the advice of legal counsel, violates the law. I'm obviously not going to participate in such a meeting. I want to make clear one more time that under the law, there is an accommodation that allows this meeting to go forward legally, and that is simply you do it as a remote meeting. If you wish to stay in the room, that's fine, but other individuals in the room,
as the chairman, I'm in the room. Please excuse yourself if you're scared to be in here. I just said if you
want to stay in the room, that's fine. But because there are other county employees who by necessity are in this room, everybody in the room has to follow the law.
I don't see Derek in the room.
So
Derek's presenting from his
I'm
remote.
sorry. I think I have the floor. Do I?
Well, I don't know. You're stumbling and stuttering there, Commissioner. Make a point.
I am making a point.
The point is Derek's not here. He's going to present from his remote
Mr. Chairman,
location.
you granted me the floor. Are you taking that away now?
No.
Okay. So the law provides an accommodation, an alternative. If you can't comply with the mask mandate in this room and run a lawful meeting, then I would recommend that we recess till 10 o'clock. We reestablish as a remote meeting. And if you want to conduct that remote meeting from your chair where you're seated now, I certainly don't have any objection to that, so long as it is a lawful meeting and the people in the room have masks. It isn't about you, respectfully. It is about county employees who have to be here. We cannot subject them, require them to be in a room where the law is being broken as a part of their duties. They don't have a choice but to be here. We cannot compel that. That would be a second unlawful act. Now, I don't desire to disrupt these proceedings any more than is absolutely necessary, but I am not going to participate in an unlawful meeting. And if we have to do this week in, week out, then inevitably, I believe it'll end up in court and we'll let the courts decide. The only concern I have there is that you appear unwilling to accept the 30 decisions on the constitutional matter. So I don't know if you would accept a court's decision in this one, but that's where we're headed unless we can have a lawful meeting. So again, my recommendation is recess till 10, go to a remote meeting, and people in the room need to comply because county employees are here. I just simply need to know if that's acceptable to you or not, and I'm offering that as a motion for the board. Looking for a second. It's the lawful path.
There's been a motion made. Is there a second?
I'll second it.
Got a motion and a second. Discussion.
Thank you. I think I've already said my piece.
Yeah, you have plenty. So if you two would head to your meetings rooms, I'll stay in the chamber. We'll conduct the meeting. And any county employees, if they don't feel safe in here, please go back to your offices and we will conduct the meeting here in this room.
Mr. Chairman.
That way everybody will be safe and they feel secure in their own office where there's no other bodies around.
Mr. Chairman, if I may. I don't think there's been a vote. There's been a motion and a second.
There's been a motion and a second. All in favor, say aye.
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 All opposed? Nay. Okay, so I don't think it's going to take 30 minutes for you to get down to your office. So maybe we can reconvene a little sooner than that because that's 30 minutes away.
Mr. Chairman, you don't have that prerogative. There was a vote.
I voted against it, so I was asking for maybe an amendment so we can keep the meeting going in an orderly manner and timely manner.
Motion's already been passed. There's no
Okay,
time
then
for
head to your office, Commissioner Peck, please, so we can continue on with the business.